Thank you for your patience. We had a little technical difficulty there. So, this workshop will be given live streaming, and the topic of the workshop is COVID-19, the coronavirus crisis, and how it impacts businesses. What you as a business owner need to know about this crisis and how different employment laws are being passed and different labor laws that you have to follow. Just as a kind of intro, it's no surprise in the past 2 weeks, I think nearly all of us have seen our lives just turned upside down by the devastating impact of this coronavirus, this COVID-19 pandemic. There are a lot of unknowns about the path of this virus. We don't know, for example, how long some of these drastic changes that have been taking effect will be in effect for. There's a very lingering fear of serious illness or death or an economic devastation. People are unsure what's going to happen to their business, and they're wondering. And understandably, many people are experiencing some fear and anxiety, much like the anxiety I was feeling for the last half an hour trying to get this thing up and running. But in any event, when you're in that anxious state, it's sometimes very difficult to take in all the information coming at you. And so what I'd like to do today is focus on three main points of relief and also three main points of employment law legislation that applies to you as a small business owner, whether you have one employee or 500 employees, whether you have a single solopreneur or whether you have several companies. And in doing so, I'd like to narrow the focus. I think in this age now, we're kind of all being hit with a ton of information all at once. So I'll talk about the recent federal legislation that just passed. That's the Coronavirus Emergency Family Medical Leave Expansion Act, mainly the Families First Coronavirus Response Act, and how that applies to employers. I'm also going to speak about some New York State legislation that you as a business owner in New York should be aware of, and that's both the recent executive order, the New York State on Pause executive order, and some changes to New York State's unemployment legislation and some quarantine leave. So mainly we'll be covering basic topics of changes to paid family leave, what you need to provide, changes in terms of sick leave, what you as an employer need to know, and then some questions on unemployment insurance. And lastly, we'll talk about some things I know everyone's been thinking about, which are some stimulus packages, what is in the works right now, what kind of tax credits can you as a business owner apply for, and what must you do to be eligible for those tax credits, and how do you relate to unemployment insurance for your workers and all this. So I hope I'm still live right now. I think I am. Liz, can you give me a thumbs up if I'm still live? I think I am, so I'm going to keep on talking here. Okay, so in any event, the first thing I'd like to cover today, and by the way, I'll be taking questions during this workshop. I think it's best to go in segments, then go from there. Okay, so I see I'm still live. Great. Okay, so the Families First Coronavirus Response Act is a very large, comprehensive stimulus package, and there are many provisions. It's extremely voluminous. My focus today will keep you narrowly focused on two main provisions that you need to know about, and a third provision that has not yet passed. And the first provision we're going to talk about today, and this is again from your perspective as an employer, but many of you watching might also be an employee somewhere. You might have a startup company and you're working somewhere as a B job, so this can impact you as well. So this is the issue of the Emergency Family and Medical Leave Expansion Act. So many of you might be aware of, have heard of the FMLA, the Family Medical Leave Act, and that was passed in 1993, and that basically applies broadly to companies that have at least 50 or more employees in a 75-mile radius from a location. So it's little bigger companies, 50 or more employees. It provides 12 weeks of unpaid leave. This is the Family Medical Leave Act as it has been written for the last 27 years and still stands today. And it allows workers to take this unpaid leave, protected leave, under certain health conditions, or to care for a close family member or spouse or child who is sick or injured, care for their own personal health issues. So what this new legislation is doing, meaning this new Families First coronavirus impact law is doing, is they're taking the FMLA and they're expanding it when it relates to COVID-19. So let's talk about what that looks like. So the first change we see is that this new act, this new federal law, covers a larger array of employers. It covers employers that have up to 500 or fewer employees in their ranks. So this again means that if you have 500 or fewer employees, which could be, for example, you are a business of maybe 499 people or a business of 10 people. A business of 10 normally would not be subject to the FMLA, but under these new expansions, under this current legislation, you are in fact eligible or covered by this legislation. So what this requires right now is that if you have 50 or fewer employees, you being the employer, the business owner, you have to provide up to 12 weeks, and that's of leave. 10 of those weeks are paid leave, which is different again than the Family Medical Leave Act. And 2 of those weeks, the first 2 weeks, are unpaid leave. Now, with the unpaid leave for the first 2 weeks, I'll get to that in a moment. Let me talk about, again, who the eligible employees are. This law applies to employers, so it applies to basically employers meaning, again, a company, a public or private sector. It exempts employers in the healthcare industry, emergency response, so private organizations that provide, for example, EMT type services, public hospitals, etc. But all other public and private employers are covered. And then the eligible employees would be any employees of your company. Think about your employees who are full-time or part-time, it's important to note, who work for your company, work for the employer for at least the last 30 days prior to taking their leave. So it used to be the employee, or I should say it still is, for FMLA leave, an employee has to have worked 1,250 hours for your company. Now, not true anymore. It could just be 30 days. So an employee who worked 30 days at your company can be eligible to take this leave. Now, the question then comes up, I'm sure, when can they take this leave? Under what circumstances can they take this leave? And it's a very narrow type of leave they can take. And here's where the law states right now. The leave provided, like I mentioned, the first 10 days are unpaid. Quite significantly, your employees do have a federally protected right. They have an option. They can choose to use any of their current PTO, vacation time, any sick leave they have maybe banked up from your company, and they can apply it in those 10 days. They can opt to do that, so that the first 10 days of the leave, which are unpaid by the statute, are paid in some way. Now, you as an employer cannot request that your employees take their sick leave in those 10 days. And importantly, you can't use whatever paid leave, whatever vacation days, you cannot ask an employee to use that time in lieu of this paid leave. So think of it as the federal statute, right? It supersedes whatever your current company's employment or vacation PTO might be. So you have this leave where people can take these 2 weeks unpaid. Again, employee can decide to supplement that with their vacation or paid time off if they have it accrued. And then the remaining 10 weeks of the leave are paid as follows. We have full-time employees, and those employees are receiving 2/3 of the regular rate of their pay for the number of hours the employee would otherwise be normally scheduled. So just to clarify also that in order to qualify for this leave, as it relates to COVID-19, the main and frankly only criteria right now is that the employee is unable to work or unable to telework, can't work from home, can't work right now, because they're taking off to care for that employee's child, right, defined as somebody under the age of 18. So that's an employee who is under 18 years old, who is an employee of your company, and they're home, and either they're taking care of their child whose school or whose child care provider or service is closed, which in this case I think would apply to anybody watching now who has children. I know that my wife and our son's child daycare is closed right now. So if an employee is seeking this leave, if they come to you and say, hey, my child's school is closed, my child's daycare is closed, And it's closed due to a public health emergency of COVID-19, right? It's a COVID-19 related closure. So this can't be a school that closed down because the school's funding ran out. It has to be closed based on the coronavirus and all the different public health ordinances around that. So then what is that employee entitled to, right? They come to you, they can show evidence that their childcare, or it could be their nanny or their au pair, maybe can't work for them anymore, and they're home with their child. And remember, they're not working, and they're not telecommuting or teleworking. So then the next question is, what are they entitled to? And that's where we get to the pay that they have here. So those employees can take, again, those 2 weeks of unpaid time, and then 10 weeks paid at 2/3 of the employee's rate. Now, the pay for each day is capped at $200 a day. So you might be doing the math in your head and thinking, geez, I've got some high paid managerial employees who are making a fortune, and if I have to pay them 2/3 of their salary, that could be $2,000 a week. And just to reassure you that the cap is $200 per day, and it's usually a 5-day week, so you've got about a $10,000 over the 10 weeks total per employee that they can claim under this emergency expansion of the Family Medical Leave Act. So one common question I've gotten, what about my part-time employees? Are they eligible? Answer is yes. And the next question is, okay, I have a part-time employee, he or she works 20 hours a week. Their child's in daycare closed, they cannot work or telecommute. Maybe their child has special needs, maybe they have full-time obligations to attend to. How much do they get paid? 2/3 of what? And so the answer to that question is, for employees who have worked for the last 6 months, you take the average of the hours the employee has reasonably worked or expected to work at the time of hiring, and then you calculate either 2/3 of their hourly rate if they're an hourly employee. If they're a part-time salaried employee, that's pretty easy. Just take 2/3 of their salary, of their weekly salary. This law also provides certain protections around job reinstatement. So it's important for you to know as an employer, especially now when you might be restructuring your company, you might be deciding we have to get some layoffs, whom are we going to cut? Whom are we going to keep? That if you have an employee who's out on this Emergency Family Medical Leave Act expansion and they're taking this leave, employers with 25 or more employees, you have a legal obligation to return your employee to the same or equivalent position. So if you're going to cut employees, that would not be the person to cut, ideally. Employers with less than 25 employees do not have to return the employee to their previous position if they can show that doing so would create undue hardship or economic duress during this time. So if you're a 10-person company or firm, or you're a store or a tech startup maybe, and you only have 10 employees and 2 are out on this emergency paid family leave, when they come back, if you can show that you cannot put them back in their place, there's just not enough money, you are protected. You don't have to worry about a retaliation lawsuit. So I would also note that employers of 50 employees or less can try to be exempted from this act by claiming undue hardship, by writing to the Secretary of Labor, contacting the New York State Department of Labor as well, although this is a federal bill, but you can go through both channels and state your case. I would caution, though, that it would be a very arduous audit of your financials, your books and records, and so if those are not 100% up to date or in place, you might want to rethink, going for that exemption from this. Rather, you might want to instead either A, borrow the money, possibly if possible, to fund these paid leaves, or B, talk to your employer insurance if you have employment law insurance, see if your insurance is covering this, or C, wait for the tax credits, which I'll get to in a moment, because there are tax credits that are allowed for small businesses who are required